Hello and welcome everyone for another episode of Mentor Hour with Lawyer. Today we have Advocate Devansh Gandhi with us to guide us on the topic employment procedure in India, appointment to termination. Advocate Gandhi provides comprehensive legal services under civil and criminal law. He is skilled in arbitration law, Consumer Protection Act, labor and employment law, POSH and litigation. We welcome you to the Mentor Hour, sir.
Thank you. Should I begin?
Yes, sir, of course.
Okay. Firstly, I'll just try to mention a lot of compliances also that are done under the labor laws, apart from the procedure from appointment to termination or resignation, basically. So, under the Constitution of India, labor is a subject in the concurrent list, which where both the central and state governments are competent to enact legislation subject to certain matters being reserved for the center government. Firstly, it is crucial to understand that the Indian laws make a distinction between an employee and a workman, which comprise of two categories of a workforce. A workman is any person employed in any industrial premise where a manufacturing process is being carried on, or in any kind of work that is connected with such manufacturing process and are not part of any managerial or supervisory functions. Employees are the white collar, I mean, uh, people involved in the managerial and supervisory functions and have a contractual basis of employment. The process of hiring an employee and a workman may be different, and that solely depends on the skill sets and designation that the company is looking for. So, talking about appointment, in the selection procedure of a suitable candidate for employment, CV or profile plays a crucial role in creating the first impression about the person and screening the right person for the job. Eligibility and suitability of a candidate for a specific post is identified after screening and interview. This process, though sounds simple, involves a lot of meticulous actions at every step and involves selection of only white collar employees. For workmen, I'll say a specialized skill set is taken into consideration depending on the duties to be performed by the workmen. Initially, in the appointment of employees, the crucial considerations that an establishment should keep in mind while initiating the appointment process is conducting a background check of an employee. Firstly, the establishment focuses on verifying the credentials of the candidates. Mostly, the procedure followed in our country is that the candidates are selected through various placement agencies, also known as headhunters. However, it is crucial that any such arrangement between the company and the headhunter firm should be on the basis of a written agreement. Such an agreement should specifically provide for, amongst other terms, the roles and responsibilities of the headhunter firm, the expectation of the company, and consequences of the breach of the above expectations. The placement agencies or headhunting firms also offer the services of doing a complete verification of the information provided by the candidates. Though this would be useful for the company, however, it would always be prudent to cross examine the credentials at the time of interviews and retain copies of the qualification certificates wherever necessary. But one thing to be kept in mind is that while conducting the background check of an employee, the establishment should ensure that the privacy of a person or a prospective candidate is not violated. Thereafter, once a candidate is finalized, the establishment should issue an appointment letter. An appointment letter is a legally binding document that establishes a contractual relationship between an employer and an employee and confirms the terms and conditions of such employment relationship. An employment agreement or appointment letter clearly details the roles, responsibilities, and obligations of the employer and the employee, along with various other terms and conditions. Presently, there is no central law that requires mandatory issuance of an appointment letter. However, some states, under their respective Shops and Establishments Act, which are obviously applicable to their respective states, provide for a specific requirement to issue an appointment letter. In the organized sector, the appointment letter or employment contract read with the HR policies constitute the terms of employment. However, the Code on Occupational Safety, Health and Working Conditions, which is yet to be implemented, mandates issuance of an appointment letter to promote formalization in employment. So, as per the code, Every employer shall have to issue an appointment letter to every employee on his appointment in the establishment, and the law will state the format in which the appointment or the terms of appointment must be encapsulated. Also, if the employee has not been issued an appointment letter, that is the present employees, before the commencement of the code, he or she shall be issued an appointment letter within 3 months of the commencement of the code. As per the rules under the code, while issuing the appointment letter, the employer would be required to mention details such as date of joining, category of skill, wages including basic pay, allowances, nature of duties to be performed, and social security identity numbers including Aadhaar number, ESIC details, provident fund details, etc. This will increase the awareness amongst employees about their entitlements and can be used to resolve disputes or divergent views about the actual arrangement. And an appointment letter would also provide of a sort of, documentary evidence of employment to an employee, especially those working in the unorganized sector. Most importantly, an employment agreement provides protection to the employers as well by incorporation of clauses such as confidentiality clause, non-disclosure, and non-solicitation. These restrictive clauses play an important role in providing protection from unauthorized disclosure of information, solicitation, or taking away of existing employees and clients, and from entering into a or setting up of any competitive business which would affect the business of the employer. So once an employee is recruited and starts working, then there are certain compliances to be followed under the existing employment laws as well as under the new labor codes which are yet to be implemented. And the states are coming out with the rules. So it is pertinent to mention that not every organization can afford to or even want to spend many resources for statutory compliances. Nonetheless, it is absolutely vital for a business to be compliant to all the laws of the land. HR compliance revolves around matters related to employees that includes when and how to pay for overtime wages, processing benefits, maintaining employee documentation, separation policies, and hiring procedures. The law compliances are not just restricted to filing returns, but these records serve as evidence for the compliance of the laws and must be produced to the authorities in case there is any discrepancy or an employee makes a complaint. There are laws that are enforceable only for certain work environments or applicable to certain industries, and there are some laws that are enforceable to all the organizations. In the event of non-compliance, an organization will be subject to fines, penalties, lawsuit, loss of credibility, loss of contract, and maybe even closure of business. Compliance of labor laws is basically the set of terms or conditions of employment framed under the central laws as well as under the state laws which an organization is required to comply with, and is primarily focused on safeguarding the protection of the rights of employees. There are labor laws on industrial relations like Trade Union Act, Industrial Employment Standing Orders Act, Industrial Disputes Act, Social Security and Welfare laws like uh, Employee State Insurance Act, Provident Fund Act, Employees Compensation Act, Maternity Benefit Act, Payment of Gratuity and POSH, and laws on occupational safety, health and working conditions like Factories Act, etc. Apart from laws relating to wages like Minimum Wages Act, Payment of Bonus Act, Payment of Wages Act, etc. For the purpose of securing interest of labor class workers, the Indian government has introduced and amended various labor laws for different purposes, which include industrial law compliance, wages, working hours, conditions of service and employment, equity and empowerment of women, prohibitive labor laws, and training of employees, social security, and others in the form of terms and conditions of employment. Every act has its implications as well as it imposes responsibility of implementation on compliance of labor laws on the employer. Now, talking about the duties of employers under the labor laws, once a candidate is recruited and up to his termination or resignation, it is the duty of employer employing the employees to introduce the terms and conditions of various labor laws as may be applicable to them in their HR policy or in their appointment letters to provide all the benefits as the central or state government is intended to provide. which includes minimum wages, working hours, safety at workplace, retirement benefits, special protection to women, and others. Abiding to labor law compliance is essential for every big and small company to keep their businesses safe and secured from any legal entangles. Talking about the advantages of complying with labor laws, abiding by the labor laws is beneficial for employer as this increases productivity in view of lower absenteeism in the enterprise, increases profit, employers status increases in the society, increases recognition in view of regulatory authority, and strict compliance of all labor legislation reduces or even eliminates penalties, damages, fines, and that may be imposed by the authority. To improve the labor relations, strong communication and understanding of the workers as to their behavior requirements is a must. For employees, the compliance of labor laws is beneficial as it increases their social security as well as secure timely payments of wages, gratuity, bonus, overtime, compensation, etc. of the workers, which will in turn result in lower again absenteeism in the organization and inculcate a sense of belongingness towards their employer. The compliance of labor laws is beneficial for the governments as their revenues also rise phenomenally by way of filing fees and other charges. And it is extremely important to mention that pursuant to the ease of compliance rules introduced in 2017, the relevant central rules enacted have been amended to replace existing forms of registers with the combined registers notified under the said rules. Consequently, now the requirement of maintaining various type of registers has been reduced to the combined registers under the ease of compliance rules. The employer can also maintain the registers in electronic form. It is a, I mean, very good step by the Labor and Employment Ministry that has developed a software to enable maintaining such registers in digital form. Also, the software, I mean, developed by the ministry has been uploaded on the Shram Suvidha portal of the ministry to enable establishments to download such software for free. And as you are aware, the government has introduced labor codes to consolidate the existing labor laws and bringing uniformity on the same. I shall share views on the same, including compliance required under the codes, obviously subject to exception for certain establishments as notified by the government. So, firstly, talking about the code on wages, it requires the payment of minimum rate of wages. It says that no employer shall pay to any employee wages less than the minimum rate of wages notified by the appropriate government. And wages for overtime work, the employer shall pay employee for every hour or part of an hour so worked in excess at the overtime rate which shall not be less than twice the normal rate of wages. And it also talks about mode of payment of wages. All it says that all wages should be paid by check or by crediting the wages in the bank account of the employee or by the electronic board. Certainly, I mean, there are exceptions to this. There is a certain limit that will, I mean, no later once the codes are implemented. And there is sorry, there is time limit for payment of wages. I mean, if it is on a monthly basis, it should be paid before expiry of 7th day of the succeeding month, or for certain industries it is also 10th day of the succeeding month. And it talks about payment of bonus or eligibility for bonus. So it says that there shall be paid to an employee by his employer who has put in at least 30 days work in an accounting year. An annual minimum bonus calculated at the rate of 8 and one third percent, that is 8.33% of the wages earned by the employee, or 100 rupees, whichever is higher, whether or not the employer has any allocable surplus during the previous accounting year. However, it also says that the total bonus, including the annual minimum bonus, shall not exceed 20% of the wages earned by the employee in the accounting year. And there is a time limit for payment of bonus and how to pay bonus. Talking about the code on occupational safety, health, and working conditions, it says that the employer shall be responsible to maintain in his establishment such health and working conditions for the employees, such as first, the adequate and suitable facilities for washing for to workers for male and female separately. There should be bathing places and locker rooms for male, female, and even transgender employees separately. placing a place of keeping clothing not worn during working hours and for drying of wet clothing, sitting arrangements for all the workers obliged to work in the standing position, adequate standard of canteen or food facility or workers. I mean, in an establishment employing 100 or more workers, including contract labor ordinarily employed. There is an responsibility of employer for maintaining health and working conditions, adequate first aid boxes or cupboards with contents readily accessible during all the working hours. Again, the code prescribes that there should be an ambulance room in every factory, mine, and other construction work wherein more than 500 workers are ordinarily employed. Central government is also coming out with the rules to provide for the facility of crèche having suitable rooms for the use of children under the age of 6 years of the employees at suitable location. It also talks about hours of work and annual leave with wages. It says that no worker shall be allowed to work in an establishment for more than 6 days in a week. There shall be displayed and correctly maintained in every establishment a notice of periods of work showing clearly for every day the periods during which the workers may be required to work, maintenance of registers and records and filing of returns. So basically the courts provide rules on how to maintain the registers and all that. It says that an employer of an establishment shall maintain register electronically or otherwise containing such particulars of workers, work performed by them, number of hours of work constituting normal working hours in a day of rest allowed in every period of 7 days, etc. And these returns should be filed electronically or otherwise to the inspector come facilitator or the authority as per the rules prescribed. Now, talking about the code on social security basically deals with the provident fund, pension fund, and the insurance, etc. It says that employer shall make a contribution to the fund. Also, gratuity shall make a contribution to the fund, which shall be 12% of the wages for the time being payable to the employees, or such percentage of the wages as may be notified by the central government, and the employees' contribution therein should be equal to the contribution payable by the employer. Again, there are certain limits that are going to come up once the code is implemented. There is it talks about employees pension fund, which says that the employer's contribution under the employees pension scheme shall not be exceeding 8 and one third percent of the wages. Talking about gratuity, it says that the employer shall pay gratuity at the rate of 15 days wages to an employee who has rendered continuous service for not less than 5 years, except for termination of the employment of an employee due to death or disablement or any other happening for every completed year of service or part thereof in excess of 6 months. If I may add to this, I mean, the government is working for a fixed term employment contract uh, workers also to provide gratuity. Supposedly, if a worker works for around 2 years or 3 years, so they should also be provided on the pro rata basis. It talks about maternity benefit. It says that no employer shall knowingly employ a woman in any establishment during the 6 weeks immediately following the day of her delivery, miscarriage, or medical termination of pregnancy. It says no woman shall work in any establishment during the 6 weeks immediately following the day of her delivery, miscarriage, or medical termination of pregnancy. It also says that every woman shall be entitled to and her employer shall be liable for the payment of maternity benefit at the rate of average daily wage for the period of her actual absence. That is to say, the period immediately preceding the day of her delivery and any period immediately following that day. Again, no woman shall be entitled to maternity benefit unless she has actually worked in an establishment of the employer from whom she claims maternity benefit for a period of not less than 80 days in the 12 months immediately preceding the date of her expected date of delivery. And it says that every woman entitled to maternity benefit shall also be entitled to receive from her employer a medical bonus of 3,500 rupees or as such amount as may be notified if no prenatal confinement and postnatal care is provided for by the employer. So that amount should be paid free of charge if the care is not provided by the employer free of charge. It says that every establishment having 50 employees or such number of employees as may be prescribed by central government shall have the facility of crèche within such distance I mean, the distance, and the government is again coming out with the proper rules for them. Provide that employer should allow 4 visits a day to the crèche by the woman, which also should include the intervals of rest allowed to her. The courts also talk about the employee compensation and compliance relating to that. So supposedly on reporting of accident, injury, death, and occupational disease shall be made within a period of 24 hours of the occurrence of such accident or the occupational disease comes within the knowledge of the employer, and provided that any fatal accident shall be reported immediately. It talks about employer's liability for compensation. If personal injury is caused to an employee by accident or an occupational disease listed in the schedule in the court arising out of and in the course of his employment, his employer shall be liable to pay compensation. So talking about compensation in the case of death or injury in plantation, if death or injury is caused to any worker or a member of his family as a result of the collapse of a house provided by the employer in a plantation, and the collapse is not solely and directly attributable to the fault or on the part of any occupant of the house or to a natural calamity, the employer shall be liable to pay compensation. Where the death results from the injury, an amount equal to 50% of the monthly wages of the deceased employed multiplied by the relevant factor. So where there is permanent total disablement results from the injury, an amount equal to 60% of the monthly wages of the injured employee multiplied by the relevant factor. Also, where there is a temporary disablement, whether total or partial, results from the injury, a half month payment of the sum equivalent to the 25% of monthly wages of the employee. This code on occupational safety, health, and working conditions has been introduced by the Labor and Employment Ministry, and it has proposed one license, one registration, and one return for establishment. So that is a very good step taken by the government. Talking about the compliance under the POSH Act, that is Prevention of Sexual Harassment Act, which is, I mean, really relevant these days. So to be POSH compliant, an employer has mandatory obligations to fulfill in ensuring that working women do not face sexual harassment at the workplace, which includes forming internal control committee, which is to be headed by a female presiding officer, and forming the sexual harassment policy for the establishment, creating awareness about it, and giving providing training and orientation, and also making disclosures regarding compliance with POSH laws, and reporting number of sexual harassment complaints received in a year, the number of sexual harassment disposed of in the year, and cases pending for more than 90 days in its annual report. Mere forming of internal complaints committee, or forming the sexual harassment policies, or making disclosures in the annual report don't live up to the liability imposed on the employers by the government. Establishments have to recognize that complaints of sexual harassment cannot be treated as an empty formality. It is a duty to act judicially, and the ICC or the internal complaints committees of corporates must grapple with rival claims and the dictates of legal process for relief, and provide relief to the victims of sexual harassment must meet the formidable challenge of adducing evidence for the accused, the right to proclaim his innocence till proven otherwise, for the management, the dilemma of compliance, and the compulsions of containing the damage to the corporate brand. So, but these are early days. But the legislation is already a battleground rife with allegations of non-compliance and prejudice of ICC members, violations of procedure, evidence not considered, biased conduct of proceedings, and wrongful reprieve of the accused by the management. Coming to the termination of an employee, I mean, which is the most tedious task for the employers, it is pertinent to note that mass terminations can result in exorbitant and lengthy litigations for years. In my personal experience, I've seen that. So, therefore, actions should be taken only after considering various factors, such as number of on-roll or off-roll employees, number of contract labor or outsourced labor, casual labor, temporary labor, fixed term employees, years of service, and the CTC structures, location of units, and some important clauses such as probation, retirement, retirement age, etc. To avoid litigations, generally companies enter into golden handshakes, or we also call it VRS, or voluntary resignation or retirement schemes, which is an advisable solution. That is, if only there is absolutely nil possibility of restarting productions. With respect to non-workman employees or the white-collar employees, reductions are easier to be done as they are not covered by the Industrial Disputes Act. These employees are governed by their respective contract of employment. It is advisable to take written consent in case of pay reduction. Also, according to the Specific Relief Act, a contract of personal service cannot be enforced. Maximum the employees can do is sue for damages and compensation. Since white collar employees have fear of termination, generally taking consent from them is not so tedious. However, in case an establishment is not running into losses or same are negligible, reductions for these categories may also be avoided. Just as white collar employee cannot be forced to be kept in job, employer too cannot force them to work. Another category of employees are the contract labor, that is the outsourced employees. This is basically a huge chunk in the Indian work structure. A major percentage of the workforce of India is through third party vendors. These employees are governed by the Contract Labor Regulation and Abolition Act, or CLR, we call it. Such employees work through third parties, nomenclature, and as contract vendors or outsourced agencies. However, as per Section 21 of the CLRA, it is the duty of principal employer to see that monthly wages are distributed to these workers, and any shortfall becomes liability of the principal employers, which can be recovered from the vendor. Several issues need to be seen, such as since how many years the contractor has been engaged for, whether workers same or changing in different years, time period since workers are working, hours of work, power of appointment, disciplinary measures, control and supervision, responsibility of statutory benefits, etc. Basically, the nature of arrangement between principal employer and contractor needs to be examined. If arrangement is genuine termination of contract, then it may be looked into. If the possibility may be looked into and handled in such a way that litigations are not too high. These terminations can also result in costly litigation for years together. Therefore, for this category, also schemes are framed for easy terminations or parting ways. Inter alia, I mean, considering above said factor which I have just told. Another category of employees are the contractual or fixed term employees. Often, contractual and contract labor are confused. uh, I mean, terms between the employers by the employers, and contract labor are the ones employed through third party, whereas contractual or fixed terms are ones employed for fixed duration or project for time period. These employees can be terminated as soon as the contract ends, or even before the contractual terms, if provides it is provided in the contractual terms. It is generally advisable not to hire these employees for many years. I mean, that makes the terms of contract look artificial. I mean, camouflage to flout provisions. So, and there are employees such as casual laborers, daily wagers, or temporary workers. And for terminating such employees in case they have completed 240 days of continuous service in a year, same procedure is required to be followed as required for regular workers under the Industrial Disputes Act. In case there is a misconduct, workman level employee can be terminated after conducting inquiry, which includes issuance of charge sheet, inquiry, show cause notice, etc. Now, there can also be a case of retrenchment. So, retrenchment and closure compliance includes 15 days wages for each completed year of service, apart from notice pay as well as intimation permission from the government. Amount of notice pay 1 month or 3 months for retrenchment or closure, and intimation or permission from government in case of layoff. Retrenchment or closure depends on number of employees as well as the kind of organization. Principle of last come first go is to be followed. That is, the junior most workman to be retrenched first and the senior most last. So this was basically a holistic or bird's eye view of employment laws from appointment to termination or resignation, and including the compliance under labor law vis-a-vis the labor codes. So just to conclude, I'll just say that considering the change in employment pattern and the current scenario of employment in India, labor compliances ensures a thorough check of companies' policies. I mean, the establishments should get themselves audited from a expert labor auditor and procedures with the goal of preventing prosecution or lawsuits. So it does not only protect the interest of the stakeholders but also leads towards better governance and value creation for the organization.
Thank you so much, Mr. Gandhi, for joining us for the session and briefing us about the procedure of employment in India. I hope a lot of people will benefit from this innovative session. Thank you so much.
Thank you. Thank you for inviting me.